Hello and good evening. It's exactly 10 p.m. where I'm at. I don't know what time of day it is for you if you're watching this right now. Thank you for tuning in. I sincerely appreciate it as a smaller channel, or I should just say small channel. Yeah, I do apologize in advance because I will be very honest. I sometimes ramble a little bit, but I am nonetheless glad you tuned in, and I will try my best to keep this as cohesive as possible. Yeah, without further ado, let's get into it. So, the field of personal injury is quite familiar to many of us. I'm sure we've all seen the billboards, the ads on the side of public transportation, like buses and benches, public benches, and I've even seen ads at the gym, like on Crunch TVs. But if you're like, Sonia, I don't know what the hell you're even talking about right now. I kind of just clicked on this video because I have nothing better to do, or, I have a lot to do, and I just need somebody to tell me what the hell personal injury even is. So, luckily, I'm here to tell you exactly what that field is. Personal injury law is essentially a branch of law where I'll just use an example. This is a very generic example, but if you get hit by a car, or if God forbid you hit somebody with your car or another type of vehicle like a motorcycle or something like that, you can be liable for damages. And if you think it just stops at, hitting somebody and their initial injuries, oh no no. Oh no no. Some of these injuries can be long lasting, like back pain, vertebrae, disc. I forgot the name of it. I'm sorry. It's 10 p.m. Like disc dislodgings, fr- fractures, headaches, concussions that can drag out, and these injuries can drag out cases for years and years and years. You might hit somebody with your car in 2022 and it come to bite you all the way in the butt in our year 2026. Personal injury has to deal with any sort of physical or emotional mental trauma that happens to you due to a accident. I'm sure that includes anything under the sun to I believe slip and falls as well. Like if you slip and fall in a restaurant. Yeah, if you ever slip and fall on like a Chili's, you can technically sue Chili's if, they were supposed to clean up that mess and it was just hanging around there. The definition for personal injury off of Cornell's website is personal injury and any harm to a person's body, emotions, or reputation as opposed to property rights. Another definition is a personal injury is physical or emotional harm caused by another party. I hope that gave a better understanding as to what the field of personal injury is. A philosophical take on the field, if you will, is if you think back on humanity and how we've treated each other within even the past like 6 months, um, you would know that we're not very kind to each other. So if you think about the field of personal injury, it's holding somebody accountable for their actions, which throughout history, it's not always we haven't really had the best track record for as a civilization. I'm like, where did this field even start? I mean, you can think back to like constitutional law, at least in America, and understand the origins of that. But to me, I'm like, well, personal injury can happen anywhere. So, what was even the first case? Like what started this whole field to begin with? So, if you're curious like me as to how this field came about, I will stop rambling and just get into the meat of this video. Imagine this. You're riding your horse down a road at full speed. It's 1809, the road ahead is partially blocked, and somebody's put up a pole to repair some construction. You don't see it in time, and you crash. Now you're injured. Whose fault is that? Today, you'd probably call a lawyer who would recommend you a doctor, or call a doctor who would recommend you an attorney. Uh, there'd be an insurance claim, maybe a lawsuit, and maybe even a settlement. But in 1809, the legal system had no real answer for you. And the case that tried to figure it out, a dusty English courtroom drama involving a horse, a road obstruction, and one very unlucky rider. This didn't just settle an argument between two men, it helped to kick off an entirely new area of law that today generates hundreds of billions of dollars in settlements every year. This field shapes how doctors practice medicine, how cars are designed, and how companies decide what warning labels to put on their products, and whether ordinary people can actually get justice when someone else's negligence destroys their life. That area of law is called personal injury. And today we're going to trace its history all the way back from ancient Babylon through medieval England and through the dramatic courtrooms of early 20th century America, all the way to what it looks like now in 2026. Let's start from the beginning. If you think personal injury lawyers are a modern invention, well, you're mostly right by title, but the idea that one person who injures another should have to pay for it, that goes back as far as civilization itself. Around 1754 BC, a Babylonian king named Hammurabi issued what is often called the world's first written legal code. And although ancient, some of its contents are strangely familiar to us. Code 229 of Hammurabi states, and I'm paraphrasing here, if a builder builds a house and it collapses, killing the owner, that builder shall be put to death. Hammurabi's code is famous for the phrase an eye for an eye, the lex talionis, or law of retaliation. Now, that obviously doesn't reflect our modern understanding of modern negligence as it pertains to the legal system, but it did establish something important, that harm demands a response from some sort of legal system. Fast forward a few centuries to ancient Rome. The Romans were obsessed with codifying law, and they did something that Hammurabi didn't. They started to distinguish between intentional and accidental harm. And they started to think about compensation rather than just punishment. A key document to the Romans was the Lex Aquila, which passed around 286 BC. The law established liability for damage wrongfully caused. At first, it mainly covered damage to property, such as slaves or livestock, but, property to them, not what we would consider modern property. But over time, Roman jurists interpreted it more broadly, and it began to cover personal injury as well. The Romans even developed an early version of the negligence concept, culpa, meaning fault or carelessness. They made a distinction between deliberate harm and harm caused through carelessness. That distinction between intentional wrongs and careless wrongs is the bedrock of modern personal injury law. When Rome's legal system was codified in the 6th century AD under Emperor Justinian, I don't know why that's so hard for me to say. It's just Justinian. This Roman legal thinking got preserved, packaged, and eventually transmitted to medieval Europe, and then to England, and then to America. Now we're going to jump to medieval England. I do apologize that we're jumping around a little bit, but these are just some core concepts from different eras that kind of tell us a little bit about personal injury. I'm going to get into the case that really kind of laid the foundation for modern personal injury because, stoning somebody for, talking about your mom poorly, uh, I don't think that would fly for emotional negligence or damages in our year 2026. So, sorry. Okay. Now we jump to medieval England. And while the feudal era wasn't exactly known for legal innovation, English common courts started developing what they started to call trespass actions, which were lawsuits for direct physical harm caused by someone else. An interesting note here, these early trespass actions were basically strict liability. If you hit someone, you owed them compensation, even if it was an accident. Intent didn't matter much, fault didn't matter much. If you caused the harm, you had to pay up. My voice is getting hoarse. Shout out to everybody that talks nonstop. Now, fast forwarding all the way to 1809, we get to the case that most legal historians point to as the foundational modern personal injury decision, Butterfield versus Forrester, decided in England in 1809. So what the heck happened here? I heard something about a horse and a carriage, or somebody getting hit by a horse and a carriage. I don't understand. Well, about to tell you right now. Edward Forrester was doing some road repairs near his house in Lichfield, England. He'd put up a pole across part of the road, and not the whole road, but just part of it. It was still passable if you were paying attention. Not my words, just, what I read about. Enter in one Butterfield on horseback. He's moving fast, very fast by the counts. He saw neither the pole nor the obstacle in time, struck it, and was thrown from his horse. He was, of course, injured. And after being flown off his horse, Butterfield sues Forrester for negligence, arguing that Forrester had no right to block the road and that his obstruction caused the injury. Now, here's the thing. Forrester probably was negligent. He did put the pole across a public road, and that is dangerous. Under the old strict liability approach, this might have been a slam dunk, but Forrester's lawyer made an argument that would change legal history. He said, yes, maybe Forrester did block the road, but Butterfield was driving recklessly. He was going too fast to stop. He contributed to his own injury. So, what did the judge think of this? Well, the court agreed. Judge Lord Ellenborough delivered a ruling that said something like this: one who contributes to the negligence cannot recover damages from another. This was called contributory negligence, and it was enormous. Here's what it meant. If the injured person was at all at fault for their own injury, even a tiny bit, they got nothing. Zero. The law essentially treated them as if they were disqualified from any sort of compensation. And for about a century and a half, this rule dominated both English and American law. It was pretty brutal because imagine you're a factory worker who is injured by defective machinery, but who also maybe wasn't standing exactly where they should have been. Under contributory negligence, he gets nothing. Even though the machine was defective, even though his employer knew it was dangerous, nada. The rule protected powerful defendants, railroads, factories, manufacturers, at the expense of ordinary injured people, workers, and it shaped a legal landscape that tilted heavily against plaintiffs. But here's what's important about Butterfield versus Forrester. It established negligence as a legal framework in the first place. Before this, the law was sloppy and inconsistent about when you could actually sue for injury, but this case helped to at least formalize the idea that there needs to be fault. Someone needs to have done something wrong before liability attaches, which was a major step forward, even if the contributory negligence piece was later recognized as deeply unfair. The negligence framework itself was foundational. So we have our origin story. 1809, one rider, one pole, and one horse. An illegal precedent that echoed for generations. But the story obviously doesn't end there because negligence law in 1809 was still just a little baby infant, little mitochondria. The cases that came after, especially in the 20th century, would reshape it beyond recognition. Now we're going to go over some more landmark cases. So if you thought the first case in 1809 with the horse, the pole, and the man flying off after hitting the pole was interesting, just wait until we get to Scotland. There's a woman here. She drinks her ginger beer. And something about a snail, there's like some snail bits in there. The year is 1832. The place is Scotland. A woman named May Donahue goes to a cafe in Paisley with a friend. The friend buys her a ginger beer. The ginger beer comes in an opaque bottle. You can't see through it. Donahue drinks some, pours the rest out into a glass, and discovers the decomposed remains of a snail. She claims she became seriously ill after drinking this and then wants to sue, rightfully so, because that is disgusting. But here's the problem. She didn't buy the ginger beer, her friend did. And under the law at the time, you could only sue somebody that you had direct contact with. Donahue had no contact with the cafe, her friend did. And she certainly had no contact with the manufacturer, Stevenson. So, under the rules of the day, she had no case, except the case went to the House of Lords, Britain's highest court. And Lord Atkin wrote an opinion that became one of the most famous passages in legal history. He said, and this is the quote that every law student learns, that you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor, who then in law is my neighbor. The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation. Thy neighbor, not just the person you have a contract with, not just the person you sold something to directly, anyone who could reasonably be foreseen as potentially harmed by your carelessness. This established the modern duty of care doctrine, and it blew the doors off old limitations on who could sue. Manufacturers now owned a duty not just to the store that bought their product, but to the end consumer, to the person who actually bought the bottle. The dead snail and the ginger beer became the foundation of modern product liability law. Another breakthrough happened slightly earlier in America, a case called McPherson versus Book Motor Co., decided in 1916 by the New York Court of Appeals. Donald McPherson bought a Buick. One of the wooden wheels on the car had a defect. It collapsed while he was driving, throwing him from the car and injuring him. McPherson wanted to sue Buick, the manufacturer. The problem was that McPherson hadn't bought the car directly from Buick. He'd bought it from a dealer. Old law said you can only sue who you contracted with. McPherson's contract was with the dealer, not Buick. The judge on this case was Benjamin Cardozo, arguably the greatest American judge for the 20th century. And Cardozo said, enough with this privity nonsense. If a manufacturer makes a product that is reasonably certain to cause injury if defective, they owe a duty of care to all foreseeable users, not just the direct purchaser. Buick had made the car. Buick's negligence had produced the defective wheel. Buick was liable to McPherson, even though McPherson hadn't bought from Buick directly. This decision opened the floodgates for product liability lawsuits in America, and for the first time, ordinary people could hold manufacturers directly accountable. All right, this Judge Cardozo figure comes up again because he's in another famous case that went into a completely different direction that actually limited liability. And it's one of the most interesting puzzles in all of tort law. If you're curious about tort law, I will probably make a video about that. Palsgraf versus Long Rhode Island, 1928. Helen Palsgraf was standing on a train platform some distance away. Railroad guards were helping a passenger board a moving train. The passenger dropped a package. This package contained fireworks, and nobody knew about this. The fireworks exploded. The explosion knocked over a heavy scale at the far end of the platform. That scale fell on a Miss Helen Palsgraf, injuring her. She sued the railroad. Cardozo said no. The railroad's guards could not have reasonably foreseen that helping a passenger board a train would cause an explosion that would knock over a scale that would injure someone standing far away on the platform. Liability extends only as far as foreseeable harm. The railroad owed no duty to Palsgraf because her injury was not a foreseeable result of their actions. This case established the concept of proximate cause, the idea that while there may be a chain of causation connecting a defendant's action to a plaintiff's injury, liability stops at the point where harm was no longer foreseeable. Otherwise, think about it. Liability could extend infinitely. The railroad could have caused an explosion, which caused panic where somebody bumped into somebody else who dropped their groceries, or somebody slipped and fell on their head. Where does it end? Palsgraf drew a line, and that line still governs how we think about the scope of liability today. By the mid 20th century, one more enormous shift was coming, and it changed everything for consumers. In 1963, the California Supreme Court decided Greenman versus Yuba Products. The case involved a defective power tool that injured its user. The judge, Justice Roger Traynor, ruled that when a manufacturer places a defective product on the market that causes injury, the manufacturer is liable even if they weren't negligent. Even if they weren't negligent. This is called strict liability. Under strict liability for defective products, you don't have to prove the company was careless. You just have to prove that the product was defective and that it could hurt you. This was enormous. Before Greenman, if a pharmaceutical company made a drug that injured people, you had to somehow prove that they had been careless, that they should have known about the danger and didn't act on it. And this is incredibly hard to prove. After Greenman, you show that the product was defective. Full stop. In 1965, the American Law Institute codified the principle in the Restatement Second of Torts, Section 402A, and it became the law in most American states. And the era of massive product liability litigation began. Now, remember that brutal contributory negligence rule from Butterfield versus Forrester, the case with the horse and the pole? The one that said that if you were even 1% at fault for your own injury, you got nothing? Well, courts and legislators eventually decided that this was deeply unfair. The solution was called comparative negligence. And here's how it works. Instead of the all or nothing rule, you compare the fault of both parties. If a jury decides that the defendant was 80% at fault and the plaintiff was 20% at fault, the plaintiff covers 80% of their damages. They got 4/5 of what they were owed. Not everything, not nothing, but something proportional. Most US states have adopted some version of comparative negligence. Some states use pure comparative negligence, where even if the plaintiff is 99% at fault, they can still recover 1% of their damages. Other states have a more modified comparative negligence where the plaintiff can only recover if they were less than 50% or 51% at fault. This reform rolled out mostly through the second half of the 20th century, fundamentally shifting from those who could recover in personal injury cases. Suddenly, plaintiffs who were partially responsible for their own injuries could still get something. Okay, so now you're probably like, all right, Sonia, I get it. There's a lot of cases that eventually led up to what PI is like today, but where is this going, Like what about modern day? I mean, we don't really hear a lot about horses and poles anymore. Well, I'm getting there. All right, so let's talk about what personal injury law looks like, at least in the United States today, because that's where I'm based out of. Personal injury law covers a huge range of cases. The most common are motor vehicle accidents, consisting of car crashes, truck crashes, motorcycle accidents. Every year in the US, there are approximately 6 million police reported crashes. Probably about 3 million of those come from Florida alone. A significant portion of those become legal claims of some kind. And then you have slip and fall cases where someone is injured on another person's property due to a hazardous condition. You also have medical malpractice where a healthcare provider fails to meet the standard of care and a patient is harmed. Think, you know, a nurse accidentally giving the wrong dosage of insulin, for example. You also have product liability, where a defective product injures someone. So this could be, I don't know, hoverboards blowing up. Did that happen? I think that did. Anyways, wrongful death, when someone's negligence causes a fatality and surviving family members bring a claim. And there are newer areas emerging constantly, from asbestos and mesothelioma litigation to opioid litigation, environmental toxic torts, and increasingly questions about tech platform liability and AI related harm. There was actually a pretty interesting case in California that's, I believe, ongoing or just recently resolved relating to social media addiction. If you're curious, I will leave a link to an article about that. Most personal injury cases settle before trial. I think that's why many people aren't exactly familiar, maybe, with what personal injury cases look like beyond car accidents. But about 95% of personal injury cases settle before trial. So you will almost never see a personal injury case go to a jury. The system is built around negotiation. A plaintiff's lawyer sends a demand letter to an insurance company. Both sides negotiate, and most of the time they reach a number that both can live with. This means that multi-million dollar verdicts you hear about on the news are genuinely an exception in most PI cases. Most settlements are far more modest. Think like a couple $1,000s, $10,000. I mean, not little money by any means, but you know. And then you also have the contingency fee, where personal injury lawyers will take anywhere from 33% of a settlement before trial to up to 40% of any jury award. The client pays nothing upfront. That's kind of where the whole tagline comes in, where it's like, we'll represent you for free, you pay us nothing, but if you win, then we're going to take a little portion. For this reason, personal injury is one of the most accessible forms of the law and representation for ordinary people. You don't need money to hire a personal injury lawyer in most cases. If you win, the lawyer gets paid, and if you lose, they don't. This is a little controversial, though, to some critics, as they argue that it incentivizes frivolous lawsuits, but it also means that someone who is actually seriously injured and can't work doesn't have to scrape together thousands of dollars to pursue a legitimate claim. Because in a PI case, you can also claim for lost wages. So if you're out of work because you were seriously injured, whether physically or emotionally, like traumatically wise, or you go through something as a result of the accident and you can prove that it's because of the accident, you can actually get like lost wages if you also lost your job. But that's kind of going into the details, complications. And now getting a little bit into torts, because torts do connect into PI cases. Like a very basic tort is, for example, getting bitten by a dog. Like if a random dog comes up to you and like out of your leg, I think you can sue for personal injury. So over the past few decades, there's been a major political and legal debate called tort reform. Advocates, often backed by business groups, insurance companies, and medical associations, argue that the personal injury system has been overloaded with frivolous lawsuits, that jury awards are too unpredictable, and that the resulting insurance costs drive up the price of everything from products to medical care. In response, many states have enacted damage caps, which limit how much someone can receive in non economic damages like pain and suffering, often in the range of 250,000 to 500,000. Some states have shortened statutes of limitations, making it harder to file older claims. Critics of tort reform, often plaintiffs' attorneys and consumer advocates, argue that these caps protect negligent corporations and deprive seriously injured people of full compensation. A cap of 250,000 might seem like a lot of money, but for somebody who is permanently disabled by a preventative medical error, to say the least, it may not come close to ever compensating for that. So this debate is very much ongoing. Some of the biggest personal injury and tort cases in recent years have been pretty massive. Some of these cases that I found were, for example, the 1998 tobacco settlements, where major tobacco companies agreed to pay states 206 billion over 25 years. This was a landmark moment showing that even industries that had successfully defended themselves for decades could eventually be held accountable, especially to such a large sum. You also have opioid litigation, where pharmaceutical companies were sued by states and municipalities for their role in the opioid epidemic, resulting in settlements worth tens of billions of dollars. You also have the Johnson& and Johnson talc cases, where the company faced thousands of lawsuits alleging that asbestos contaminated talcum powder caused cancer. I brought those cases up to show that personal injury isn't just about car crashes or slip and falls. Once again, it is a tool and a means to go after large corporations and industries that put harm on a large scale. So now that you've learned a little bit more about the field of personal injury, I know it went all over the place. Went from ancient Babylon all the way to talking about Johnson and Johnson. So everything connects. But if you're ever in a car accident or feel that you are owed some sort of compensation for anything related to personal injury, you can go out there and hire an attorney and maybe get some settlement funds. Another interesting thing I'd like to point out here is that obviously it differs very much where you are in the world. A lot of warning labels on products or banned chemicals and whatnot in other countries have a crossover with the field of personal injury. This is kind of coming to my mind now, but in the UK, you will see like pretty graphic images on cigarette casings, but in the US, you just see a warning label. So if you found this video interesting, I would love to know what you think in the comments about my commentary style or just about what you learned in the video. Always welcome to constructive criticism or what you liked. That's nice too. Okay, this is my time to go because my camera keeps falling. I don't know what it's doing. I'm not a law student or a legal expert or an attorney. So I do apologize if I got some information wrong in this video or if I mischaracterized anything whatsoever, because sometimes I do that. So I try my best not to try and get the facts right, but as you can see, this is a long video, so yeah, I do apologize if there was any sort of misinformation in here. But as always, please take care of yourself, my loves, and I'll see you in the next one.